Hello, hello. We might give it just a couple minutes for folks to log in. But hello and assalamu alaikum. Good afternoon. Happy Monday. I think I've covered all of the salutations. So we are so excited for today's webinar. We get asked a lot about today's topic, something that I work with my clients on this topic. And I just think it's so important for not only mosques and 501c3 organizations mosques and 501c3 organizations to equally have in their arsenal of things that they are continually checking and rechecking and just implementing in a really succinct way and everything. So without further ado, we'll get started. Today's topic is employment issues in the mosque. And we have two wonderful speakers today who are part of the MLFA legal division. First up is Christina Jump. She is the head of the civil department here at MLFA. She has more than 25 years of litigation experience at both the trial and appellate levels. Her practice involves civil constitutional cases, challenges to the no-fly and other government watch lists, land use, zoning law discrimination, religious discrimination in employment, religious accommodations in institutions, and defending denaturalization lawsuits on behalf of members of the Muslim community. So she does one, does all. She has incredible breadth of experience, and we're so lucky to have her here at MLFA. She joined in March of 2016. Christy is also board certified in labor and employment law, and she is also a certified mediator in the state of Texas. Christy has an amazing and inspiring resume. She has several accolades and is part of several associations. So please take a look at her bio. We'll add it to the chat, but I just wanted to touch on some of her highlights. She's also practiced in several circuit courts of appeals, which is no easy feat. And we are thrilled to have her here today with us. And last but not least is Chelsea Glover. She began her legal civil litigation career in 2015 after graduating from Duke University School of Law with her JD and LLM in international and comparative law. Before joining MLFA, she worked in commercial litigation with a focus on antitrust and employment law. She has also worked with pro bono immigration appeals, Violence Against Women Act petitions, and special immigrant juvenile status applications. So we're happy to have you, Chelsea, I'm sorry. And I wanted to give just a brief introduction of myself. I'm Sana Salim. I am the nonprofit department manager here at MLFA. And we provide, amongst other things, legal screenings for nonprofit organizations. And what that means is we do governance risk compliance assessments for 501c3 organizations. So in a nutshell, we basically get all internal documents, not all, certain internal documents from an organization. We have a rubric and we review all of those documents, everything from state and federal compliance or controls, talking about several of the things we're talking about today, employment issues, handbooks, policies, things like that. We also review financials, kind of where the money is coming from, where the money is going, who's in charge of that. And then we provide, it all culminates in a board training, about 2-hour board training. That's a combination of things that the attorneys have identified, as well as things that the organization has requested for us to review. And it's been really beneficial. I think we've gotten really great feedback from the organizations who've received this service. So please visit our website if you are interested in receiving that service. Again, that's for 501c3 organizations, and you can get more information on the website. I am also going to quickly plug our 2 further upcoming webinars in this series of, and mosques is kind of the theme, is things related to the mosque that are really important for mosques. So the next one coming up is worker classifications. Again, something that's probably not spoken about a whole lot, but we're gonna really dive deep into employees versus independent contractors versus volunteers, and kind of the do's and don'ts and things that need to be addressed when you have, or you may or may not have, all three of those categories in and around the mosque. So keep an eye out for that one. And then we have another one in November with regard to immigration issues and the mosque. So imam status, if you're hiring workers who are here on certain visas and things like that. So keep an eye out for both of those. We'll add those links in the chat. And without further ado, let's get started with our presentation for today. I will hand it over to Chelsea.
Thank you, Sana, and hi, everyone. So today's topic is employment issues in the mosque, and we're going to discuss employee handbooks in particular. So next slide, please. Why does a mosque need an employee handbook? You probably have a way that you want to run your organization, just like any other organization. And I imagine if you don't have an employee handbook, maybe there's a habit of behavior or just a kind of unspoken understanding of how things work. Well, that can lead to problems, especially down the line if you don't have anything in writing to explain why you did certain things that you did or took any specific action. So the first main reason a mosque needs an employee handbook, just like any job, is to set and manage expectations for everyone on the team. People need to know what are they expected to do when they show up to work, what are their work hours, what are their job descriptions, who do they report to. And they also set expectations for what they receive. How am I supposed to be treated by my boss and my supervisors? How am I supposed to be treated by my coworkers? How am I supposed to be treated by human resources? Where can I get the services I need to be a better employee? All of that will be explained in an employee handbook. The employee handbook also helps introduce your organization to new employees and establish your story and your values and your vision to get everyone on the same page. That's where your introduction comes in, and that's something that you can shape for yourself. But you want to make sure that all of your employees know what is the purpose of the organization that they're joining, and how can they express that purpose to people coming in or to the public. You want to explain any benefits that are provided to employees. Employees, when they choose to work somewhere, they want to receive something, whether it's compensation. Obviously, they want to also receive benefits. They want to receive time off, and they want to receive a set procedure. They want to know if they are going to be disciplined, how is that going to play out? If they're going to be terminated, how does that play out? And having that clearly explained in writing that you can provide upfront to employees helps everybody, again, get on the same page. Finally, and an understated but very important reason to have a handbook is to meet certain legal requirements. Some states cite to a handbook or cite to whatever is written in the handbook as what the employer is holding themselves to. It's their agreement with the employee. If I say, for example, we're going to get to this later on, but if I say you can be terminated after so many warnings and I terminate you without following that procedure, and it's not necessarily established that it's an at-will relationship, the employee can then go to the court and say, well, you promised me something, and this is not how it happened. Similarly, especially nowadays with discrimination and harassment, especially sexual harassment, some states have affirmative defense will be having a specific policy in your handbook. If you don't have an anti-harassment policy, then you don't have the benefit of saying that you did everything you could to protect your employees from harassment. So these are just an overview of some of the main reasons that you will want to have an employee handbook in writing if you don't have one already. Next slide, please. So this slide just lists a number of topics that we're going to go over through this presentation on what to include in the handbook, kind of from beginning to end, but of course it's up to you how you want to arrange it. You want to introduce your organization, explain the expectations for work and also behavior. You want to explain what compensation people are going to receive, any benefits, any specific policies. We're going to talk about social media policy that you may consider including. We're going to talk about the law applicable to discrimination and harassment, and how to formulate your anti-discrimination, anti-harassment policy. And of course, you'll want a discipline and termination policy. And next slide, please. So the first and possibly easiest part of the handbook is introducing the new employee to your organization. And that's something that your management or your team can come up with together. You're going to want to talk about, basically you want to make the new employee feel excited to join the organization. Explain what organization they're joining, what's its history, how did it get to where it is now, who is in charge, who's the leadership, what is the mission, what sets this mosque apart from other mosques, what sets this mosque apart, or what is this mosque position in the community and its role. For religious organizations, you want your employees to also spread the message and share that with the community. So you want to give them as much information so that they can repeat that mission to other people, to not just the community, but also to new employees. That way, your organization feels cohesive. Next slide, please. Work expectations. What that is what is the day-to-day required for employees? When we can start with, when are employees expected to work? When are they expected to report to work? When will they be counted as late? How many days of the week are they supposed to work? Who does what? What are their job roles? What are the descriptions for those job roles? What's your team look like? Who is your supervisor? Who reports to who? What's the chain of command? How far up does it go? You want to explain all of this so that new employees know what they're expected to do. They know that it's in writing, that they can always refer to it if they have any questions. You also want to include information about how often will employees be evaluated for failing or for whether they meet these expectations we set out. So what are performance reviews going to look like? When do they take place? What are they evaluated on? Is there a rubric? All of this is to say, what are the expectations for your average work week? If your employees don't know what's expected of them, they're not going to conform to that behavior, and they're not going to be as efficient, as effective as you want them to be as their employer. Next slide, please. Okay. And closely related to this is also behavioral expectations. What conduct is expected of your employees? What conduct is allowed? What conduct is prohibited? You want to talk about keeping a respectful environment. You want to talk about how is the leadership supposed to treat their employees? How are employees supposed to respond to leadership? In a religious organization, there are probably more rules about what kind of deference applies to who is in charge, whose word on certain religious teachings is going to be the final say. What am I expected to do to comply with that? Is there a dress code? That's common in most work environments, but of course for a religious environment, it may be more explicit, more laid out. There may be more differences in employee dress for men versus women, and for people in religious teaching roles versus the regular staff. You may consider also having a modesty code. Again, that just explains for everyone what are they expected to how they are expected to act and behave in the organization, and also who's responsible for enforcing these expectations. That gets to the last procedure for evaluating any misconduct. If an employee has a complaint about someone, where do they go? Who do they report it to? How is that investigated? How is that issue resolved? All of these go into the conduct that you want for your organization. And again, like this cartoon helpfully explains, is if you don't explain these expectations to your employees, they're not going to conform to that behavior. And so you're going to have a lot of confusion and inefficiency about the work environment. Okay, next slide, please. Sorry, next slide, please. Okay. Oh. Previous slide, just a little bit. I think one more previous. I think we're okay. This is the employee's favorite part of the handbook. Compensation. That's employees go places so they can get paid. They go to work, so they want to know what are they getting paid, when are they getting paid, how frequently are they getting paid, and how are they getting paid. So are they getting paid biweekly? State that. When should they expect their paycheck? Is it going to come in on a Friday? Is it going to come in on the 15th or the 30th? Um, all these, you want these things clearly stated because that's what the employee wants to know. That's what they're going to take home to their families and say, okay, this is how I'm going to make my money. And if they can't, if something happens, they need to know who to contact. Who's responsible for payroll? How do they resolve that? How quickly does it get resolved? Um, Very important in terms of keeping your employees happy. Um, if you are going to incorporate bonuses and raises and you want to set out a clear procedure for that, you don't want there to be discord amongst your employees if someone gets a raise for a reason that's not stated. Even if you are going to give raises for reasons that are up to the discretion, say that. Well, if you put it in writing, they can't expect you to do something different, and that is as long as it complies with the law, then you're okay to do that. But a compensation policy that explains when, what employees get paid and when and how is essential to keeping your employer group happy. Okay. Also related to that are benefits. Employees don't just receive money; they receive time off, they receive health benefits, dental. They want to know what benefits are in there. So that's where you list all the benefits you provide. Do you have a health plan? Do you have a retirement plan? Any insurance? Any holidays and leave? Even those things should be clearly stated. Especially leave time. Are you going to, is it going to be one big bank of leave? Is it going to be specific types of leave? And now all of that is going to depend, of course, on the laws applicable to where you are. Each state has different laws for the required leave. Some states don't require you to offer time, some states do. You also have the federal laws about pay and what time gets counted. Um, so to have these things clearly stated out, of course, is essential. Then you want to make sure it's clear who gets what benefit. If, for example, some employees say, we'll offer you health insurance if you work here for 90 days. That needs to be in writing somewhere. Um, if volunteers aren't entitled to benefits, that needs to be in writing somewhere. If employees have to work a certain number of years to get life insurance, for example, that also needs to be in writing. Again, just for clarity, explain the rules so that everybody is on the same page. This is going to be, again, like I mentioned, an area where you really want to check your state law because each state is different. Some states require certain benefits to be provided. Some states require you to give out specific sick leave. Some states require, there's specific reporting for how that works. And some states require that you pay out vacation leave upon termination. If it's something that you accrue and you've got a bank of time, some states do not let you terminate people without giving them that bank of time in a monetary value. Um, and that will, of course, affect the benefits that you ended up providing. It can be very tricky. All right, next slide, please. We're going to talk about a social media policy because that's a very hot topic these days. The internet is forever and everyone is on the internet. The internet is probably your easiest way to communicate with the public. And people are increasingly looking at people's social media pages and going to their employers saying, your employee said this, your employee said that. What are you going to do about it? So having a clear social media policy will help you respond to those questions and help your employees know what to do. As you can tell by the news, employee social media posts can then reflect negatively on the organization. So first you want terms, what is your social media? What are people allowed to say, on duty versus off duty, or not what they're allowed to say, what they're allowed to do on duty or versus off duty. You can have a rule that says anytime you're on duty, you shouldn't be on social media at all. You can have rules about the different places that you post. If There, you may have specific rules for the mosque website versus social media, and you may have specific rules for personal social media. It may be something like if your name is on your social media page, and or if it's a LinkedIn page, you have to keep it tied to employment. If it's on a religious social media group, you has to, and you're speaking as a mosque representative, you don't want someone, your employee, necessarily posting, say, blasphemous things on their social media and then claiming with their name and their mosque affiliated clothing or dress or having any kind of affiliation with the mosque on that page. Clearly state anything that's prohibited. So these are just 4 things that categorically make sense to prohibit. Obviously, don't promote illegal conduct. No disclosure of any confidential information of the mosque, that protects the mosque. No false information, again, protects the mosque. You don't want to be hit with a defamation lawsuit. Um, and you don't want your employees starting rumors about people or getting you involved into unnecessary drama. And then no obscenity. These are just classic, easy ways to that most people don't want on their personal social media anyway. So these are things that you can do to protect yourself. Okay. And next slide, please. Okay. And so this next part, we're going to have to talk a bit about the law first, because the law as applied to religious organizations is different than that for private organizations, at least for anti-discrimination. Um, I'll start a bit at the bottom. Sexual harassment is prohibited everywhere. There's no religious exemption to our sexual harassment laws in any state at the federal level. So there's no way of getting around that. And we will cover that in detail on the next slide. But Title VII, which is the anti-discrimination law that applies to employers, has a religious exemption for any religious organization. So obviously, you can't force religious organizations to hire religious leaders who are not part of their religion. That would make no sense. So any religious like church or organization or a mosque can discriminate based on religion. You can say, I'm going to only hire Muslims to work in my mosque to conduct any religious teaching or religious organizing, because that's what we do. However, you cannot discriminate on any other basis. You are not allowed to discriminate, at least on racial discrimination, disability, national origin. The courts are not, sympathetic to an idea that your religion entitles you to discriminate on these bases. One area of obvious contention these days is on sex and gender discrimination. There, obviously, each religions have specific rules between men and women, and so they're going to discriminate based on sex. So that it has to be tied to a religion. You have to have a religious reason for doing this. It shouldn't be out of the blue. Like, I personally don't like women wearing a certain color, so they have to do that. That won't work. But if you say women, they worship separately in this location, and that's where I want my female religious leaders to work, that is tied to religion, so that can work. And then I also want to bring a different law, which is the First Amendment has what's called the ministerial exception, that if you are employing what it calls a minister, which is a religious leader or instructor, and that could, a lot of jobs count for that. You'll see this often in religious schools. Some teachers have tried to say, I teach math. Why am I getting fired because I'm not Catholic? Because if the school says, well, you're part of being a teacher is teaching students in religion, and we expect all of our teachers to do that, then yes, that counts in the role of ministers. So to the extent your mosque has a variety of roles in which you expect those people to be communicating your religious principles, those would count as your ministers. Okay. And then next slide, and I'm going to pass this over to our department head, Christy Jump.
Thanks so much, Chelsea. Appreciate that. And so I want to follow up on what Chelsea just explained and where she set the groundwork really well here. So now I'm going to talk about your anti-discrimination and anti-harassment policies and the things that need to be in the handbook. As Chelsea just explained, there are some exemptions, but they're not universal. They're not across the board. And there are a lot of things that are required of all entities, whether nonprofit, whether religious-based or otherwise. So one of the first things that we recommend that any employer do is define the discrimination and list protected categories and characteristics within the handbook. So in your anti-discrimination policy, it should state what you believe discrimination to be and the characteristics that are protected. Some states and also local municipalities, even some cities or other specific ordinances, will limit this more than just federal law. So simply looking at, if you were so tempted to go to Title VII and look it up and see what that covers, it could potentially be broader than that for what affects your place of work. So you want to make sure that you know what is required in your specific local area. One of the ways to do that is with some catch-all language that, stating that our organization prohibits discrimination of any kind. It prohibits discrimination in accordance with our policies. It prohibits discrimination in any area protected by law or on any basis protected by law. Having that additional kind of catch-all language can help if there is a recent change in law. For example, it's a little tough to figure out state by state right now, and even a little bit on the federal level, where exactly the line is as far as gender is protected. Gender identity generally is considered protected, but as far as the some subtle to many people differences that can exist between whether there's gender identity, there's sexual identity, sexual orientation identity, those sorts of things, it's safer to include a catch-all provision that says any area covered by governing laws. So that'll just help you out to have that in there as well. But that sexual harassment, as Chelsea mentioned, is prohibited. And you can state, discrimination on the basis of race, on the basis of gender, on the basis of anything else that age, anything that's going to apply universally. Go ahead and list those as the general categories along with the catch-all information. And then you want to generally go beyond what the law requires. So you want your policies to reflect at least as much as the law requires. So that's why you'd have and any other area protected by governing laws. But your policies for employees should provide more safety, if you think of it that way, should provide more guardrails and provide an even safer environment than just the bare minimum that the law requires. So there may be things that will violate your policies that do not necessarily create a legal obligation or a legal violation. And you want to specify that too. That can be done without having to delineate what it is. We're not asking everybody to become attorneys or experts on this area of law, and particularly not to just keep up with all aspects of it. But go ahead and explain that with like one sentence, that our policies may cover more than what the law requires. We expect all employees to abide by the scope represented in our handbook and covered by our policies. And with that information, you're stating that somebody can't just come to you and say, no, that's not what the law requires. I know that because I have a cousin who's a lawyer, or I have, an uncle who works for the government in whatever area. You're saying that this is what we require on site for our employment environment. And that may be more, that may be broader, that may encompass more, because you want to provide more than the bare minimum. Go ahead and provide examples of things that are prohibited. Now, I will say, be careful with this a little bit. Sometimes people think, okay, well, I'm going to do a really good thing here, and I'm going to include examples of some language and some slurs that are inappropriate. Please don't do that. We don't recommend that anybody actually include specific slurs or anything like that. I'm just saying that racially based slurs are inappropriate and violate your policies. That's enough. You don't have to specifically list any of them. But that would be an example by saying things include but not limited to racially based slurs, slurs based on gender, anything based on national origin that is offensive to others, or defamatory to, you don't have to use defamatory, that's a lawyer word, but offensive language based on any of the protected categories is something that you can list. And providing intolerable behavior. So sexual harassment, as just a very quick overview, obviously it prohibits unwanted touching. It prohibits unwanted contact. It prohibits more than that. It prohibits unwanted verbal harassment that may be sexual in nature. And it can prohibit even visual harassment. So, for example, one example that has come up in cases would be calendars that were hung up in the workplace that were offensive to some and that were considered sexually harassing calendars. So, providing examples, again, for the behavior that is inappropriate would be things like, you know, offensive touching, unwanted contact without, or inappropriate language that makes others uncomfortable, um, based on gender, based on sexual content, based on religion, based on anything else like that. So go ahead and include that information as examples. Again, keep it broad. Don't give any specifics. Don't use the offensive language itself in the policies, but giving examples like that, and that it goes beyond just touching for sexual harassment. It's not just physical contact. And we've had cases come up multiple times where an employee's response may be, yeah, but I didn't touch anybody, and so therefore, since I didn't touch anybody, um, that means that this shouldn't have to be a problem, and I didn't violate the policy. Again, your policies are not going to stop with what the law requires. The law's the floor. Your policies are going to go beyond that, and you can say, well, our policies may include more than simply what the law requires, what the law prohibits. We may prohibit more by our policies than what the law prohibits. So you want to create an internal complaint procedure and make sure that employees know about it. One risk that employees have, and something that comes up sometimes that leads to lawsuits or at least discontent and claims, is that there may be a really good procedure that you created and put in place, and it's really good. It would be really effective if used, but nobody uses it, and nobody uses that process because they don't know about it. And they may not know about it because it's in the handbook that they got when they first started working and they signed off on, and that was it. And then they haven't seen it or heard about it since then. So we do recommend, again, that there be training that happens on an annual basis. You can do different levels of training for managers versus for staff. And that training, there's a lot of different easy ways to do that. It can be done online. There are a lot of programs that make that available. The EEOC makes some of that available. That can help with this, or you can put together your own or bring in somebody to put it together. I would not recommend putting it together on your own unless you have a very knowledgeable human resources person on staff who can do that. Otherwise, it's good to have somebody come in, and if somebody from the outside, whether it's via video or it's via just bringing somebody in for the day or a half a day, comes in once a year to give the training, then that's a neutral person providing the information, and they also can highlight what your policies are. So you want to create your complaint procedure that employees know that they can go to their immediate supervisor, or they can go to a different manager and identify who's a member of management, because you want to give people an opportunity to complain without having to complain to the person they're complaining about. They need to have another out. And maybe they can all go to the top. They can all go to your board of directors and make that information available, and maybe even post it on a bulletin board in the lunchroom, in the employee break room, something like that, right above the copier, a place that employees are likely to see it if they need it. And then assure employees that any investigation as to a complaint will be confidential as much as possible. You cannot and should not guarantee absolute confidentiality, because in order to do a good investigation, you've got to go speak to the person they're complaining about. You've got to ask other employees if they may have been in the room and something's happened. Then you got to find out if they did hear anything, if they did hear these comments, if they did see this behavior. So don't guarantee absolute confidentiality, but you say that you will keep it as confidential as possible, and only those who have a need to know because of the investigation will be aware. And even then, you can limit it so that not everybody, who has a need to know or who you interview is going to know the full details. Let people know what the investigation procedure involves, whether it involves bringing in an HR consultant, whether it's done internally and who is likely to do it, or what positions those people are who are likely to do it. Those are good things just to let employees know about. And then this is a key phrase in the law: to take immediate and appropriate corrective action. So there will be times that somebody does something wrong, whether it's a legal violation or not, or maybe just a violation of your policies, because remember, your policies are going to provide a safer environment than the bare minimum that the law requires. But if there is a violation of one of your policies, just somebody stepped outside of bounds, that does happen. So make sure that when that happens, that you take immediate and appropriate corrective action. Now, that does not mean immediately fire somebody every time anybody complains about them. You want to go through and do the investigation. You want to go through and address the issues, again, keeping it as confidential as possible. And you want to take all the right steps, take it seriously, make sure that you investigate every complaint that comes in and not just the ones that seem the most believable. And then if anything is substantiated, if you get to the point where you think, oh my, this person really did do something that violates one of our policies. So if that happens, then what you want to do is make sure that there's appropriate action taken. It's not necessarily going to be severe action. It's not termination every time. But if somebody, for example, used a term that offended someone, then make sure that there is some internal counseling and documentation, even if it's a memo to file or an email to the individual confirming the conversation occurred, stating, perhaps you didn't realize this term was offensive, but now that you know, and we're reiterating, here's another copy of our policy. And now that we have this copy of our policy, we want you to sign off that you've received it and we've reviewed it again, and therefore you know. So that's immediate corrective action. And depending on the level of the violation, that may be appropriate. It may also be appropriate corrective action to transfer a particular employee so that they're not reporting to the same individual that they complained about if it looks like that working relationship is just no longer workable. It's just not going to go well. It's not going to happen. So then that's something that you can do. Or maybe it is termination, or maybe it's a written warning or a final written warning. All of those things that you want to do them, and you want to document that you did it. Because if there is a problem, if there is something that happens, that's okay. It's not awesome, but it's okay. It does happen. And when you have your policies in place, that's done so that you can address it. Excuse me. Did not sneeze the entire time Chelsea was talking, but right now while I am. So you want to make sure that you have your policies in place so that if something does go wrong, you can address it when it goes wrong. And so make sure that you document that you did, however that may be. So if we can go to the next slide, please. All right, so discipline and termination. So when you address it, when you do this corrective action, this prompt and appropriate corrective action, what's it going to be? Well, what it's going to be can be several different things. So we've got the warning tape up there because a lot of times it's a warning if it's a first occurrence. You want, again, we discussed on the last slide a little bit, to create a progressive disciplinary procedure that we recommend in general. Again, this isn't tailored to any one specific entity or any one specific nonprofit or company, but you want to generally have a progressive discipline procedure laid out that employees will be counseled for violations of the policy as appropriate to the violation. Again, so you're leaving yourself some room for judgment there because some are going to be more severe than others. You're going to hold some people to a higher standard than others. A coworker is going to be disciplined at a different level in many situations than a manager. Manager should know better. And also, if a manager does something, that's more likely to put you at risk. So that's something where you want to leave a little bit of an in there without having to explain every possible contingency. And you leave yourselves a little bit of wiggle room by saying, we follow progressive discipline as appropriate, which can include a verbal warning, a written warning, a final warning, and termination. Management reserves the right to take appropriate action, which may include skipping any of these steps if the violation warrants that, if the violation is severe enough. Also, if somebody has previously had a warning for an activity, then if you would normally give a verbal warning for something that happens afterwards, you're going to elevate that to a written warning because you've got somebody who didn't take it seriously the first time or just it didn't sink in the first time. So that's something that you want to specify. There are some actions that would result in immediate termination or an immediate final written warning. And so again, you want to leave yourself a little bit of room for that because it's a judgment call at the discretion of management, not based on this person's how severe they think it is. And it's also not up to the person who is complaining. As much as they may say this is super severe, this is the worst I can try to come up with, but the worst that I can imagine, and therefore you got to get this person out right now. Maybe it's not something that rises to that level, or where you've taken that level of discipline before for a comparable action. So again, understand that some actions are going to require more severe discipline, even with the progressive discipline policy in place, and that's okay. Having a progressive discipline policy in place doesn't mean you're giving up that judgment right and that managerial judgment. You still have it, and you should still use it. If you get to the point that you need to terminate somebody, make sure that you are explaining to them why, very briefly. This is not a time to debate. Once you've made the decision to terminate somebody, having the termination letter in hand at the time that you terminate them is a really good idea. And that termination letter should say you are being terminated for a violation of company policies, specifically because we found that you violated our sexual harassment policy, violated our anti-discrimination policy, whichever policy it is. You want to refer to that. And you want to provide that to the person, make sure that they understand it. Now they've been notified of it. They can't claim that they didn't have any information about it. So it should explain the grounds for termination. It does not have to explain every example, and it does not have to give every detail. The termination letter is not necessarily the place for that. The final termination conversation is not a place where you're going to give somebody the chance to rebut it for the first time. That needs to happen before you decide to terminate. You give somebody the opportunity to address it, unless it's something so clear, like you've got video and you looked at your security video and your security video shows exactly what happened, and there's no other interpretation to explain what happened in the video and what you can clearly see or hear in the video, and therefore you're taking action right away. Then you can state, after investigation, we find that you violated the policies of the company, and list which policy it is that was violated. Then you want to explain to the individual what happens upon termination. And by that, not necessarily like, okay, now good luck. Not that, but you want to say, okay, well, we are ending your employment. Your health benefits will continue to the end of the month, or whatever the situation may be. You will receive your final paycheck on X date. Make sure that you check your state law for your particular state, because different states have different requirements. For example, in Texas, if somebody is terminated as opposed to quits voluntarily, then that person has to be given their final paycheck within 6 days of the termination. And if they quit voluntarily, then they get their paycheck at the next regularly scheduled pay period. So each state will have some variation like that. So make sure that you look for that. And explain if they, if they need to file anything to continue their health insurance. Afterwards, tell them who they can contact for that. If you have a particular individual that they can direct people to verify what dates of employment that they worked for you and what their position was, then go ahead and do that and let them know about all of that information. That all should happen at the time that you are terminating them. Now, they probably won't absorb it all. Normally, when somebody is terminated, that doesn't all stick. So they may need to follow up with someone and give them the name of the person they should follow up with. And let's go to the next slide. Okay, so risks of not having an employee handbook. Let me go ahead and bring Chelsea back in here at this point. So I think Chelsea wanted to be able to address these as well.
Hello, everybody, back. So what are the risks of not having an employee handbook? As we've gone over, main risk is that people won't understand what's expected of them, and then they will either misbehave or ask a lot of questions. You're going to have to end up explaining yourself over and over again, answering the same questions if there's not any written question or any written place where the specific answer is located. You're going to have poor behavior. You're going to have disciplinary procedures that are inconsistent. You're going to have employee and discontent among your workplace if the rules aren't being applied equally to everyone. If one person goes to one leader and they get X result, and then that same person goes to a different leader and they get Y result, that's going to create a problem for your employer workplace. That's going to lead to a lot of distrust. And then on the legal basis, you're not going to have any protection, or at least the ability to provide even an affirmative defense to a discrimination and harassment claim, because you have no policy. As I mentioned at the start, some states hold, or in their anti-harassment laws, say that if you don't have an anti-harassment policy, you don't get the benefit of saying that you are addressing harassment, because where's your policy? So you do want to have all these written, have an employee handbook that addresses the things that we've discussed. So our next slide, then we'll talk about the tips for your employee handbook. So next slide, please. Okay, my most essential tip, having worked on lots of these: hire an attorney who knows the law applicable to where you are, especially the state law. Federal employment law, almost every employment lawyer will understand the federal laws. It's the state laws that are going to be your biggest issue. Employment laws vary by each state has different employment laws. Some municipalities within states have different employee laws. I know from firsthand experience, we worked for a Texas company that moved into California and having to rewrite their entire handbook for their California employees, because California has a different set of laws. California has a much more employee-friendly employment code with lots of different regulations that protect employees. As when Christy was going over the discrimination claims, federal law protects a limited number of classes. California protects far more than that. And they have specific laws, even their leave laws. They have more leave laws than Texas does. They have different payout upon termination laws. California's is extremely strict. If you fire someone in California, they need to be paid within 72 hours, not 3 business days, 72 hours. And each day that you don't pay them, you are penalized by California law. So you need someone to know exactly what the difference, what each state's laws are for their employees, and to make sure your policy includes that. This goes, not to harp on about it, but different types of leave happen in different states, and you're required to put those in. As we said, really the law is a floor, not a ceiling. You want to protect your employees. You want your employees to feel safe where they are. And so you don't want to just give them the bare minimum. And you want to make it clear to employees that you're establishing the policy for your workplace. You're not holding them just to the law. You're saying, in this workplace, this is how we're going to treat people. I don't care how you treat people outside, but in here, we're going to respect everybody on these bases. And if you don't like that, this is not the place for you. Finally, you want to make sure the employees know what's in the handbook. Make sure they read it, make sure they sign it, make sure so new employees have that be one of the first things they do. If you make any changes, go over it, have a meeting, go over the different policy changes, have everybody sign the new changes, and make sure that people know what's in the handbook and they know where they can go to get any kind of concerns they have about the policies redressed. And so with those tips, you should be well on your way to making your employee handbook and making your organization, your mosque, a lot more efficient and more successful. All right. And with that, I think we are ready to answer questions.
That was great. That was really helpful. I thought it was applicable. I hope that organizations can take away what you said today and really just jump into structuring or restructuring perhaps the current employee handbook that they have. I know one of the early slides almost gave like an outline, Chelsea, that you had talked about. So I believe this is going to live on YouTube. So if anyone from your organization needs to come back and reference it, or if you want to loop in, another employee or HR person, please go to the MLFA YouTube page, and this webinar should be there for you to reference. So I'd love to open it up to questions. Please log in. I think you have to log into your YouTube account to be able to access the chat. I do have a couple that I'll just go ahead and start off with while people are warming up to submitting any questions, and then you guys can decide who's going to take the question. But the question I received is, what are employees' responsibilities in case there is a community conflict related to the mosque, i.e. if there's like community objection to firing an imam, which I know can be a common occurrence with mosques?
I'd be glad to speak to that one. We actually have had mosques approach us for some advice on this in the past. And first of all, I know that with most religious institutions, while the working employment relationship is with the employees, with the individuals, and that's the first obligation. It feels like there is a contract with the community as well. It feels, there is a relationship with the community, and while it is not legally relevant in the least, it is, as a practical matter, something that's going to come up to an extent. So first, I want to stress that as far as handling an investigation, a complaint, anything like that, um, it is very important to keep that confidentiality as much as possible within the investigation context. And you do not want to be the ones who are responsible for sharing information that can then become a source of defamation, that becomes a lawsuit, and then you've got to prove the thing that actually happened, as opposed to just saying that you made a determination based on managerial discretion. So the fewer details, the better, as far as what's communicated to the community as a whole, to begin with. Also, understand that there are risks going the other way. So you don't want to say too much and be responsible for potentially defamation against somebody that's going to land you in court. But there are also, and specifically within the religious employer context, problems where institutions have given a glowing reference to somebody who was terminated, for example, for violating a sexual harassment policy, or for abusive behavior toward another employee. And then the entity gives a really positive recommendation that omits all that and says how good they are and what a great coworker they are and all this other stuff. And then the second entity that hires them after that, based on that recommendation, may try to take action against the first one, saying, you misled us. You told us there was no problem here. So understand it can go both ways that way. So I would say a couple aspects here. First of all, you don't want to give anything that is too detailed to the public, to anyone outside of the employment relationship, about an employment decision. And you can state that for the privacy of all involved, you are not able to give details. It is fine to say that the individual, if you decide to let them go, then that the individual is terminated because of a violation of company policies, a violation of organization policies, a violation of the code of conduct. I would not go much further than that. There may be pushback, and there often will be, because there'll be people who really, really like this person and they're really good at their job in many aspects, and yet. So when there is pushback, if there is a community outcry, if there is something where people are saying, I can't believe you fired this one, I think we want to be able to come here and see this among. We want to be able to have this interaction. Again, just stick with, I understand that this was a difficult decision to reach. We respect the opinions of everyone in the community. We commend all of the good work this individual has done while here, and we made the decision that we had to make as an organization, based on all information available to us at the time, and we can't discuss it any further. And you really do have to just stick with that and not go any further. Now, that's where your board of directors can help you, and here's where you scapegoat a little bit. When you have a board of directors, what you can say and what you can have the on-site people say, the person who answers the phones, the people who are getting these questions as the frontline points of contact, is that this was a decision made by our board of directors, and I can't speak for them, and I'm sorry, I just can't violate any employee confidentiality concerns, and so I really can't give you anything more. I'm so sorry. And then, if you want, direct them to someone on the board of directors, but there should be one and only one person who the board of directors has designated to be the community contact for a situation like that. And then that individual should, again, pretty much stick to the same script, but at least people will feel like they were given an opportunity to discuss with someone else.
That was a great answer. I like that you brought in the board of directors, because I know that could be a question too, is like, well, who
made this decision?
Who made the decision, right? And how did that decision get made? And it was put to a vote, or who, all that kind of stuff. So just having one centralized kind of, like you said, person, community representative, or community contact person on the board of directors to kind of just put it all out there. It's hard, right? Because being in that community, being in the Muslim community, there's family friends, and there's, an auntie or an uncle who's like, well, just tell me what happened. And you have to keep it professional in that sense.
Correct.
Everyone on the board of directors is also likely going to be attending that mosque and in that community, but you really have to maintain that sense of professionalism and say, look, this was the decision. They violated XYZ code of conduct or handbook or policy, and just keep it general. And you can't tell auntie what she wants to know, and that's
right.
that. And
she'll be mad, but then she'll also respect it eventually.
Yeah, I agree. Okay, next question. Are there any special laws or guidelines by individual states, especially related to employees of religious organizations?
I could try this one. To my knowledge, there is not any state laws that are directly applicable to employees of religious organizations. And I think that's partially because of, the First Amendment really does prohibit the government from interfering with religion. And so you don't want to have laws that are only targeting religious organizations. So you're probably not going to see that. What I anticipate seeing a lot more is some states providing even more protection or like more exemptions for their religious organizations in their state, from a variety of laws. But that's I will absolutely be checking to see like whether that changes. But I do think that's why you don't see many laws. There just aren't that many laws applicable to religious organizations because they have that huge First Amendment protection.
And I agree with that. I think in our current environment, one thing to be aware of is that there may be other aspects that end up having that impact of different laws that, while not specifically stated as being a law pertaining to a religious organization, it may impact religious organizations differently. So, for example, if you run a school as part of your religious entity, and if your state is one of the ones that just recently passed laws about what needs to be taught or how things need to be taught, and you need to keep in compliance, and that's your concern, is, am I in compliance with my state's laws about education and what I have to teach versus sticking with our religious tenets, and what we believe and what we teach, and we don't want to be contradictory to that. So I do recommend getting in touch with a state-specific attorney, an attorney in your state who knows your state's laws. Generally, I will say that there are some religious exemptions in there, and courts tend to be pretty friendly to those. But us telling you that you'll ultimately win in court means that you went through a lot of trouble by the time you got there. So checking ahead of time before that as a more practical solution, and consulting with someone who is an attorney and knows your state's laws and is in your state and licensed in your state is a much better solution to do in advance, so that you can be aware of where those may be and what exemptions may apply.
Sure. I wanted to touch on one thing that Chelsea had talked about too. Sorry, we're shifting gears a little bit, but just about everyone knowing where the policies are and that they exist. And so obviously a big part of that is doing an onboarding and training for new employees. But then one of the things I tell my clients is that, it doesn't matter if you have 5 policies or 100 policies. If nobody knows about them, it really doesn't matter. Like, people have to know where they are, where they're located physically, digitally, whatever, and know how to apply them, right? If they want to complain about something, where is that policy? Where's the complaint? What do they do? Who do they go to? And so those things are really important. And I think one thing that is very taboo or is not talked about as much in the Muslim community, in the mosque community, is kind of having policies surrounding imams in particular, right? If you have imams who are conducting youth programs, like, is there a policy about that? Is there a policy on that there's not going to be one imam to one child in a closed room? Is there a policy? I know no one wants to talk about that, but these are important things. Is the Quran lesson that they're giving in the open area of the mosque, like off to a corner? I mean, are these things that your board is talking about? I know we want everyone to have good intentions, and everyone does have good intentions, but these are the realities, and we've seen that, and we can't shy away from having those open discussions with your board of directors about, okay, what's the policy going to be specifically with children or with minors or with younger students who are coming in to learn from the imam. Of course, we all hold this level of respect and we hold the imam on a pedestal, but there have to be, certain checks and balances in place.
And I will say also that having those policies in place, like Sana just said, making them known and available, will protect your employees and protect your imam as well. So if you state, like, look, we go by these policies, we require that there be two adults who had passed background check or anything like that, then when we do that, the imam can stick with that and say, these are the policies and they're right here, and everybody can see that.
Right. It goes both ways.
Mm-hmm.
So just to wrap up, I do want to remind you all, we have 2 more webinars in this series. So like I said, the next one is on worker classifications, employees versus independent contractors versus volunteer. We touched on, obviously, employee-related issues today, but we'll go much more in depth next time. And then the immigration-focused one, which will be coming up in November with our head of the immigration department, Kate Brady, will be on that one. Another reminder is our free governance legal clinic. So we will be doing this for any and all, 501c3 organizations. We do have a certain capacity. So, sign up if you are interested, if your organization is interested in having an attorney review your governance policies. And I think that should be it. Sorry, I have actually one more super quick question, if we can get this done in the next 30 seconds. It's, does an Islamic religious organization have a right to deny employment to a Muslim LGBTQ? You kind of touched on it a little bit in one of your slides, but.
Yes. So if there is there's like a religious conflict, so you think that just doesn't align with your values as a mosque, that's something that you can do. At least I think that would be the argument in the court. If they were challenged on that, you would say, this is what we don't believe that aligns with what we consider to be proper Islam and how we want our mosque run. And so even though they are of the same religion, we don't agree with them about their sexuality. And so you definitely don't want them or if you say, I don't want them instructing children, I don't want them to be restricted religion. That's how that would work. If they were applying to be like the janitor, that wouldn't work because and that they would never interact with the community, then it's a lot harder to defend that. But as long as you can tie it to religion, that would be the response.
Okay. Thank you for getting that last one in there real quick. It was just brought to my attention. Thank you all again. Thank you to Christy and Chelsea for taking the time out of your day to do this. I'm passionate about nonprofit work, and I think this is just so important for mosques and C3s to discuss, and just let's get on the same page and really work towards bettering ourselves and kind of doing our due diligence and enforcing best practices really across the board is what we're here to do. Our contact information is here. Please feel free to reach out, and I hope you all have a wonderful day, wonderful week ahead, and look forward to seeing you at the next one. Take care. Assalamu alaikum.
Thank you.